Volume 2 of the Mueller Report audiobook. We are 3/4 of the way through. We're up to part 5. We're near the end of our time together. We're up to part H, which is the President's further efforts to have the Attorney General take over the investigation. We're on to episode 19. So an overview, which is from summer 2017 through 2018, the President attempted to have Attorney General Sessions reverse his recusal, take control of the Special Counsel's investigation and order an investigation of Hillary Clinton. So the evidence here, the President seeks to have Sessions reverse his recusal after returning Sessions' resignation letter at the end of 2017, but before the President's July 19, 2017 New York Times interview, in which he publicly criticised Sessions for recusing from the Russian investigation. The President took additional steps to have Sessions reverse his recusal. In particular, at some point after the May 17, 2017 appointment of the Special Counsel, Sessions recalled the President called him at home and asked if Sessions would unrecuse himself. According to Sessions, the President asked him to reverse his recusal so that Sessions could direct the Department of Justice to investigate and prosecute Hillary Clinton. And the gist of the conversation was that the President wanted Sessions to unrecuse from all of it, including the Special Counsel's Russia investigation. Sessions listened but did not respond, and he did not reverse his recusal or order an investigation of Clinton. In early July 2017, the President asked Staff Secretary Rob Porter what he thought of Associate Attorney General Rachel Brand. Porter recalled that the President asked him if Brand was good, tough, and on the team. The President asked if Porter thought Brand was interested in being responsible for the Special Counsel's investigation and whether she would want to be Attorney General one day. Because Porter knew Brand, the President asked him to sound her out about taking responsibility for the investigation and being Attorney General. Contemporaneous notes taken by Porter show that the President told Porter to keep in touch with your friend in reference to Brand. Later, the President asked Porter a few times in passing whether he'd spoken to Brand, but Porter did not reach out to her because he was uncomfortable with the task. In asking him to reach out to Brand, Porter understood the President to want to find someone to end the Russia investigation or fire the Special Counsel, although the President never said so explicitly. Porter did not contact Brand because he was sensitive to the implications of that action and did not want to be involved in a chain of events associated with an effort to end the investigation or fire the Special Counsel. McGahn recalled that during the summer of 2017, he and the President discussed the fact that if Sessions were no longer in his position, the Special Counsel would report directly to a non-recused Attorney General. McGahn told the President that things might not change much under a new Attorney General. McGahn also recalled that in or around July 2017, the President frequently brought up his displeasure with Sessions. Hicks recalled that the President viewed Sessions' recusal from the Russia investigation as an act of disloyalty. In addition to criticising Sessions' recusal, the President raised other concerns about Sessions and his job performance with Hicks and McGahn. Additional efforts to have Sessions unrecuse or direct investigations covered by his recusal. Later in 2017, the President continued to urge Sessions to reverse his recusal from campaign-related investigations and considered replacing Sessions with an Attorney General who would not be recused. On October 16, 2017, the President met privately with Sessions and said that the Department of Justice was not investigating individuals and events that the President thought the Department should be investigating. According to contemporaneous notes taken by Porter, who was at the meeting, the President mentioned Clinton's emails and said, "Don't have to tell us, just take a look." Sessions did not offer any assurances or promises to the President that the Department of Justice would comply with that request. 2 days later, on October 18, 2017, the President tweeted, "Wow, FBI confirms report that James Comey drafted a letter exonerating crooked Hillary Clinton long before investigation was complete." Many people not interviewed, including Clinton herself. Comey stated under oath he didn't do this, obviously a fix. Where is Department of Justice? On October 29, 2017, the President tweeted that there was anger and unity over a lack of investigation of Clinton and the Comey fix, and concluded, "Do something." On December 6, 2017, 5 days after Flynn pleaded guilty to lying about his contacts with the Russian government, the President asked to speak with Sessions in the Oval Office at the end of a cabinet meeting. During that Oval Office meeting, which Porter attended, The President again suggested that Sessions could unrecuse, which Porter linked to taking back supervision of the Russia investigation and directing an investigation of Hillary Clinton. According to contemporaneous notes taken by Porter, the President said, "I don't know if you could unrecuse yourself, you'd be a hero. I'm not telling you to do anything." Dershowitz says POTUS can get involved, can order AG to investigate. "I don't want to get involved. I'm not going to get involved. I'm not going to do anything or direct you to do anything. I just want to be treated fairly." According to Porter's notes, Sessions responded, "We are taking steps. Whole new leadership team. Professionals will operate according to the law." Sessions also said, "I never saw anything that was improper," which Porter thought was noteworthy because it did not fit with the previous discussion about Clinton. Porter understood Sessions to be reassuring the President that he was on the President's team. At the end of December, the President told the New York Times it was too bad that Sessions had recused himself from the Russia investigation. When asked whether Holder had been a more loyal Attorney General to President Obama than Sessions was to him, the President said, "I don't want to get into loyalty, but I will tell you that I will say this. Holder protected President Obama, totally protected him. When you look at the things that they did, and Holder protected the President, and I have great respect for that, I'll be honest." Later in January, the President brought up the idea of replacing Sessions and told Porter that he wanted to clean house at the Department of Justice. In a meeting in the White House residence that Porter attended on January 27, 2018, Porter recalled that the President talked about the great attorneys he had in the past with successful win records such as Roy Cohn and Jay Goldberg, and said that one of his biggest failings as President was that he had not surrounded himself with good attorneys, citing Sessions as an example. Poor old Sessions. The President raised Sessions' recusal and brought up and criticised the Special Counsel's investigation. Over the next several months, the President continued to criticise Sessions in tweets and media interviews, and on several occasions appeared to publicly encourage him to take action in the Russia investigation despite his recusal. Just checking the footnotes here, looking at Trump's tweets. Why is AG Sessions asking Inspector General to investigate potentially massive FISA abuse? Will take forever, has no prosecutorial power, and already late with reports on Comey, etc. Isn't the IG an Obama guy? Why not use Justice Department lawyers? Disgraceful. A whole lot of other Trump tweets. Couldn't be bothered reading. On June 5, 2018, for example, the President tweeted, "The Russian witch hunt hoax continues, all because Jeff Sessions didn't tell me he was going to recuse himself. I would have quickly picked someone else. So much time and money wasted, so many lives ruined, and Sessions knew better than most that there was no collusion." On August 1, 2018, the President tweeted that Attorney General Jeff Sessions should stop this rigged witch hunt right now. On August 23, 2018, the President publicly criticised Sessions in a press interview and suggested that prosecutions at the Department of Justice were politically motivated because Paul Manafort had been prosecuted, but Democrats had not. The President said, "I put in an Attorney General that never took control of the Justice Department, Jeff Sessions." That day, Sessions issued a press statement that said, "I took control of the Justice Department the day I was sworn in. While I am Attorney General, the actions of the Department of Justice will not be improperly influenced by political considerations." The next day, the President tweeted a response, "Department of Justice will not be improperly influenced by political considerations. Jeff, this is great, what everyone wants, so look into all of the corruption on the other side, including deleted emails, Comey lies and leaks, Mueller conflicts, McCabe-Strzok, Page or FISA abuse, Christopher Steele and his phony and corrupt dossier, the Clinton Foundation, illegal surveillance and Trump campaign, Russian collusion by Dems, and so much more. Open up the papers and documents without redaction. Come on, Jeff, you can do it. The country is waiting." What's the footnote on that one? Well, that was a tweet on 24th of August 2018. On November 8, 2018, the day after the midterm elections, the President replaced Sessions with Sessions' Chief of Staff as Acting Attorney General. Analysis. In analysing the President's efforts to have Sessions unrecuse himself and regain control of the Russia investigation, the following considerations and evidence are relevant to the elements of obstruction of justice. A, the obstructive act. To determine if the President's efforts to have the Attorney General unrecused would qualify as an obstructive act, it would be necessary to assess evidence on whether those actions would naturally impede the Russia investigation. That inquiry would take into account the supervisory role that the Attorney General, if unrecused, would play in the Russia investigation. It would also have to take into account the Attorney General's recusal covered other campaign-related matters. The inquiry would not turn on what Attorney General Sessions would actually do if unrecused, but on whether the efforts to reverse his recusal would naturally have had the effect of impeding the Russia investigation. On multiple occasions in 2017, the President spoke with Sessions about reversing his recusal so that he could take over the Russia investigation and begin an investigation and prosecution of Hillary Clinton. For example, in early summer 2017, Sessions recalled the President asking him to unrecuse, but Sessions did not take it as a directive. When the President raised the issue again in December 2017, the President said, as recorded by Porter, "Not telling you to do anything. I'm not going to get involved. I'm not going to do anything or direct you to do anything. I just want to be fairly treated." The duration of the President's efforts, which spanned from March 2017 to August 2018, and the fact that the President repeatedly criticised Sessions in public and in private for failing to tell the President that he would have to recuse is relevant to assessing whether the President's efforts to have Sessions unrecused could qualify as obstructive acts. B. Nexus to an official proceeding. As described above, by mid-June 2017, the existence of a grand jury investigation supervised by the Special Counsel was public knowledge. In addition, in July 2017, a different grand jury supervised by the Special Counsel was impanelled in the District of Columbia, and the press reported on the existence of this grand jury in early August 2017. Whether the conduct towards the Attorney General would have a foreseeable impact on those proceedings turns on much of the same evidence discussed above with respect to the obstructive act element. C. Intent. There is evidence that at least one purpose of the President's conduct towards Sessions was to have Sessions assume control over the Russia investigation and supervise it in a way that would restrict its scope. By the summer of 2017, the President was aware that the Special Counsel was investigating him personally for obstruction of justice. And in the wake of the disclosure of emails about the June 9 meeting between Russians and senior members of the campaign, see Volume 2, Section 2, it was evident that the investigation into the campaign now included the President's son-in-law and former campaign manager. The President had previously and unsuccessfully sought to have Sessions publicly announce that the Special Counsel investigation would be confined to future election interference, yet Sessions remained unrecused. In December 2017, shortly after Flynn pleaded guilty, the President spoke to Sessions in the Oval Office with only Porter present and told Sessions that he would be a hero if he unrecused. Porter linked that request to the President's desire that Sessions take back supervision of the Russia investigation and direct an investigation of Hillary Clinton. The President said in that meeting that he just wanted to be treated fairly, which would reflect his perception that it was unfair that he was being investigated while Hillary Clinton was not. But a principal effect of that act would be to restore supervision of the Russia investigation to the Attorney General, a position that the President frequently suggested should be occupied by someone like Eric Holder and Bobby Kennedy, who the President described as protecting their presidents. A reasonable inference from those statements and the President's actions is that the President believed that an unrecused Attorney General would play a protective role and could shield the President from the ongoing Russia investigation. The next example of potential obstruction of justice is the President orders McGahn to deny that the President tried to fire the Special Counsel. And the overview of that consideration is in late January 2018, the media reported that in June 17, the President had ordered McGahn to have the Special Counsel fired based on purported conflicts of interest, but McGahn had refused, saying he would quit instead. After the story broke, the President, through his personal counsel and 2 aides, sought to have McGahn deny that he had been directed to remove the Special Counsel. Each time he was approached, McGahn responded that he would not refute the press accounts because they were accurate in reporting on the President's efforts to have the Special Counsel removed. The President later personally met with McGahn in the Oval Office with only the Chief of Staff present and tried to get McGahn to say that the President never ordered him to fire the Special Counsel. McGahn refused and insisted his memory of the President's direction to remove the Special Counsel was accurate. In that same meeting, the President challenged McGahn for taking notes of his discussions with the President and asked why he had told Special Counsel investigators that he had been directed to have the Special Counsel removed. Evidence 1. The press reports that the President tried to fire the Special Counsel. On January 25, 2018, the New York Times reported that in June 2017, the President had ordered McGahn to have the Department of Justice fire the Special Counsel. According to the article, amid the first wave of news media reports that Mr. Mueller was examining a possible obstruction case, the President began to argue that Mr. Mueller had 3 conflicts of interest that disqualified him from overseeing the investigation. The article further reported that after receiving the President's order to fire Mr. Mueller, the White House counsel refused to ask the Department of Justice to dismiss the Special Counsel, saying he would quit instead. The article stated that the President ultimately backed down after the White House counsel threatened to resign rather than carry out the directive. After the article was published, the President dismissed the story when asked about it by reporters saying, "Fake news, folks, fake news, a typical New York Times fake story." The next day, the Washington Post reported on the same event but added that McGahn had not told the President directly that he intended to resign rather than carry out the directive to have the Special Counsel terminated. In that respect, the Post story clarified the Times story, which could be read to suggest that McGahn had told the President of his intention to quit, causing the President to back down from the order to have the Special Counsel fired. The President seeks to have McGahn dispute the press reports. On January 26, 2018, the President's personal counsel called McGahn's attorney and said that the President wanted McGahn to put out a statement denying that he had been asked to fire the Special Counsel and that he had threatened to quit in protest. McGahn's attorney spoke with McGahn about that request and then called the President's personal counsel to relay that McGahn would not make a statement. McGahn's attorney informed the President's personal counsel that the Times story was accurate in reporting that the President wanted the Special Counsel removed. Accordingly, McGahn's attorney said, although the article was inaccurate in some other respects, McGahn could not comply with the President's request to dispute the story. Hicks recalled relaying to the President that one of his attorneys had spoken to McGahn's attorney about the issue. Just a couple of the footnotes here. The Post article stated, despite internal objections, Trump decided to assert that Mueller had unacceptable conflicts of interest and moved to remove him from this position. In response, McGahn said he would not remain at the White House if Trump went through with the move. McGahn did not deliver his resignation threat directly to Trump, but was serious about his threat to leave. That's from the Washington Post report of January 26. And just another footnote here from Hope Hicks. Hicks also recalled that the President spoke on the phone that day with Chief of Staff John Kelly, and that the President said Kelly told him that McGahn had totally refuted the story and was going to put out a statement. But Kelly said that he did not speak to McGahn when the article came out and did not tell anyone he had done so. Also on January 26, 2017, Hicks recalled the President asked Sanders to contact McGahn about the story. Well, that should have been 2018, really, shouldn't it? McGahn told Sanders there was no need to respond and indicated that some of the article was accurate. Consistent with that position, McGahn did not correct the Times story. Have we found a typographical error in the Mueller report? I think we did. Page 115 at the top, they got the wrong date. Anyway, on February 4, 2018, Priebus appeared on Meet the Press and said he had not heard the President say he wanted the Special Counsel fired. After Priebus' appearance, the President called Priebus and said he did a great job on Meet the Press. The President also told Priebus that the President had never said any of those things about the Special Counsel. The next day, on February 5, 2018, the President complained about the Times article to Porter. The President told Porter that the article was bullshit and he had not sought to terminate the Special Counsel. The president said that McGann leaked to the media to make himself look good. The president then directed Porter to tell McGann to create a record to make clear that the president never directed McGann to fire the special counsel. Porter thought the matter should be handled by the White House Communications Office, but the president said he wanted McGann to write a letter to the file for our records and wanted something beyond a press statement to demonstrate that the reporting was inaccurate. The president referred to McGann as a lying bastard and said he wanted a record from him. Lying bastard. The Porter recalled the president saying something to the effect of, if he doesn't write a letter, then maybe I'll have to get rid of him. Just looking at the footnotes from Porter's interview, looks like Porter did not recall the timing of this discussion with the president. Evidence indicates it was February 5, 2018. On the back of a pocket card dated February 5, 2018, Porter took notes that are consistent with his description of the discussion. COS Chief of Staff, letter from DM, Don McGann, never threatened to quit. DJT, never told him to fire. So this is right. Porter said it was possible he took notes on a day other than February 5. But Porter also said that COS referred to matters he wanted to discuss with the Chief of Staff, Kelly. Kelly took notes dated February 5, 2018 that said POTUS, Don McGann letter, Mueller resigning. Kelly said he did not recall what the notes meant, but thought the president may have mused about having McGann write a letter. McGann recalled that Porter spoke with him about the president's request about 2 weeks after the New York Times story was published, which is consistent with the discussion taking place on or about February 5. Okay, later that day, so what day is that? Where are we? What day? So that's the 5th of February 2018. Later that day, Porter spoke to McGann to deliver the president's message. Porter told McGann that he had to write a letter to dispute that he was ever ordered to terminate the special counsel. McGann shrugged off the request, explaining that the media reports were true. McGann told Porter that the president had been insistent on firing the special counsel and that McGann had planned to resign rather than carry out the order, although he had not personally told the president he intended to quit. Porter told McGann that the president suggested that McGann would be fired if he did not write the letter. McGann dismissed the threat, saying that the optics would be terrible if the president followed through with firing him on that basis. McGann said he would not write the letter the president had requested. Porter said that, to his knowledge, the issue of McGann's letter never came up with the president again, but Porter did recall telling Kelly about his conversation with McGann. The next day, on February 6, 2018, Kelly scheduled time for McGann to meet with him and the president in the Oval Office to discuss the Times article. The morning of the meeting, the president's personal counsel called McGann's attorney and said that the president was going to be speaking with McGann, and McGann could not resign no matter what happened in the meeting. The president began the Oval Office meeting by telling McGann that the New York Times story did not look good and McGann needed to correct it. McGann recalled the president said, "I never said to fire Mueller. I never said fire. This story does not look good. You need to correct this. You're the White House counsel." In response, McGann acknowledged that he had not told the president directly that he planned to resign, but said that the story was otherwise accurate. The president asked McGann, "Did I say the word fire?" McGann responded, "What you said is tell Rod that Mueller has conflicts and can't be the special counsel." The president responded, "I never said that." The president said he merely wanted McGann to raise the conflicts issue with Rosenstein and leave it to him to decide what to do. McGann told the president he did not understand the conversation that way and instead had heard, "Call Rod, there are conflicts, Mueller has to go." The president asked McGann whether he would do a correction, and McGann said no. McGann thought the president was testing his mettle to see how committed McGann was to what had happened. Kelly described the meeting as a little tense, I'm sure. The President also asked McGahn in the meeting why he had told Special Counsel's Office investigators that the President had told him to have the Special Counsel removed. McGahn responded that he had to and that his conversations with the President were not protected by attorney-client privilege. The President then asked, "What about those notes? Why do you take notes? Lawyers don't take notes. I never had a lawyer who took notes." McGahn responded that he keeps notes because he is a real lawyer and explained that notes create a record and are not a bad thing. The President said, "I've had a lot of great lawyers like Roy Cohn. He did not take notes." After the Oval Office meeting concluded, Kelly recalled McGahn telling him that McGahn and the President did have that conversation about removing the Special Counsel. McGahn recalled that Kelly said that he had pointed out to the President after the Oval Office that McGahn had not backed down and would not budge. Following the Oval Office meeting, the President's personal counsel called McGahn's counsel and relayed that the President was fine with McGahn. So the analysis. In analysing the President's efforts to have McGahn deny that he had been ordered to have the Special Counsel removed, the following evidence is relevant to the elements of obstruction of justice. A. Obstructive act. The President's repeated efforts to get McGahn to create a record denying that the President had directed him to remove the Special Counsel would qualify as an obstructive act if it had the natural tendency to constrain McGahn from testifying truthfully or to undermine his credibility as a potential witness if he testified consistently with his memory rather than with what the record said. There is some evidence that at the time the New York Times and Washington Post stories were published in late January 2018, the President believed the stories were wrong and that he had never told McGahn to have Rosenstein remove the Special Counsel. The President correctly understood that McGahn had not told the President directly that he planned to resign. In addition, the President told Priebus and Porter that he had not sought to terminate the Special Counsel, and in the Oval Office meeting with McGahn, the President said, "I never said to fire Mueller. I never said fire." That evidence could indicate that the President was not attempting to persuade McGahn to change his story, but was instead offering his own, but different, recollection of the substance of his June 2017 conversations with McGahn and McGahn's reaction to them. Other evidence cuts against the understanding of the President's conduct. As previously described in Volume 2, Section 2E, substantial evidence supports McGahn's account that the President had directed him to have the Special Counsel removed, including the timing and context of the President's directive, the manner in which McGahn reacted, and the fact that the President had been told that the conflicts were insubstantial, were being considered by the Department of Justice and should be raised with the President's personal counsel rather than brought to McGahn. In addition, the President's subsequent denials that he had told McGahn to have the Special Counsel removed were carefully worded. When first asked about the New York Times story, the President said, "Fake news, folks, fake news, a typical New York Times fake story." When the President spoke with McGahn in the Oval Office, he focused on whether he had used the word fire, saying, "I never said to fire Mueller. I never said fire. Did I say the word fire?" The President's assertion in the Oval Office meeting that he had never directed McGahn to have the Special Counsel removed thus runs counter to the evidence. In addition, even if the President sincerely disagreed with McGahn's memory of the June 17, 2017 events, the evidence indicates that the President knew by the time of the Oval Office meeting that McGahn's account differed and that McGahn was firm in his views. Shortly after the story broke, the President's counsel told McGahn's counsel that the President wanted McGahn to make a statement denying he had been asked to fire the Special Counsel, but McGahn responded through his counsel that that aspect of the story was accurate and he therefore would not comply with the President's request. The President then directed Sanders to tell McGahn to correct the story, but McGahn told her he would not do so because the story was accurate in reporting on the President's order. Consistent with that position, McGahn never issued a correction. More than a week later, the President brought up the issue again with Porter, made comments indicating the President thought McGahn had leaked the story and directed Porter to have McGahn create a record denying that the President had tried to fire the Special Counsel. At that point, the President said he might have to get rid of McGann if McGann did not comply. McGann again refused and told Porter, as he had told Sanders and as his counsel had told the President's counsel, that the President had in fact ordered him to have Rosenstein remove the special counsel. That evidence indicates that by the time of the Oval Office meeting, the President was aware that McGann did not think the story was false, did not want to issue a statement or create a written record denying facts that McGann believed to be true. The President nevertheless persisted and asked McGann to repudiate facts that McGann had repeatedly said were accurate. Nexus to an official proceeding. By January 2018, the Special Counsel's use of a grand jury had been further confirmed by the return of several indictments. The President also was aware that the Special Counsel was investigating obstruction-related events because, among other reasons, on January 8, 2018, the Special Counsel's office provided his counsel with a detailed list of topics for a possible interview with the President. The President knew that McGann had personal knowledge of many of the events the Special Counsel was investigating, and that McGann had already been interviewed by Special Counsel investigators. And in the Oval Office meeting, the President indicated he knew that McGann had told the Special Counsel's office about the President's effort to remove the Special Counsel. The President challenged McGann for disclosing that information and for taking notes that he viewed was creating unnecessary legal exposure. That evidence indicates the President's awareness that the June 17, 2017 events were relevant to the Special Counsel's investigation and any grand jury investigation that might grow out of it. To establish a nexus, it would be necessary to show that the President's actions would have the natural tendency to affect such a proceeding, or that they would hinder, delay, or prevent the communication of information to investigators. Because McGann had spoken to Special Counsel investigators before January 2018, the President could not have been seeking to influence his prior statements in those interviews. But because McGann had repeatedly spoken to investigators and the obstruction inquiry was not complete, it was foreseeable that he could be interviewed again on obstruction-related topics. If the President were focused solely on his press strategy in seeking to have McGann refute the New York Times article, a nexus to a proceeding or to further investigative interviews would not be shown. But the President's efforts to have McGann write a letter for our records, approximately 10 days after the stories had come out, well past the typical time to issue a correction for a news story, indicates the President was not focused solely on press strategy, but instead likely contemplated the ongoing investigation and any proceedings arising from it. Third element for consideration is intent. Substantial evidence indicates that in repeatedly urging McGann to dispute that he was ordered to have the Special Counsel terminated, the President acted for the purpose of influencing McGann's account in order to deflect or prevent further scrutiny of the President's conduct towards the investigation. Several facts support that conclusion. The President made repeated attempts to get McGann to change the story. As described above, by the time of the last attempt, the evidence suggests that the President had been told on multiple occasions that McGann believed the President had ordered him to have the Special Counsel terminated. McGann interpreted his encounter with the President in the Oval Office as an attempt to test his mettle and see how committed he was to his memory of what had occurred. The President had already laid the groundwork for pressing McGann to alter his story by telling Porter that it might be necessary to fire McGann if he did not deny the story, and Porter relayed that statement to McGann. Additional evidence of the President's intent may be gleaned from the fact that his counsel was sufficiently alarmed by the prospect of the President's meeting with McGann that he called McGann's counsel and said that McGann could not resign no matter what happened in the Oval Office that day. The President's counsel was well aware of McGann's resolve not to issue what he believed to be a false account of events, despite the President's request. Finally, as noted above, the President brought up the Special Counsel's investigation in his Oval Office meeting with McGann and criticised him for telling his office about the June 17, 2017 events. The President's statements reflect his understanding and his displeasure that those events would be part of an obstruction of justice inquiry. So that brings us to the end of episode 19. and our next episode we'll be looking at the President's conduct towards Flynn and Manafort and someone else whose name is redacted. But we will cover all that in the next video. Thanks. Talk to you then. Bye.